this going to turn out? We have the federal level investigating, and what's the farm going to be liable for here? Like a lot of things, this was settled out of court. It wasn't cheap though, so they're forced to upgrade manure lagoons and storage facilities. None of that's free. Big dollars to capture runoff, store manure for extended periods of time, and then dispose of it properly. Attorney fees, upwards of $1 million, and that's just attorney fees, so it's nothing to do with paying out for liability costs to neighbors and such that may have suffered property damage or bodily injury. The farmers are forced to do some well monitoring for 5 years and replace water that's been contaminated. So they'll have that cost as well. Closer to home, so moving away from Washington into Wisconsin, we have the Wilson Mutual versus Falk Farms. Anybody familiar with this case? Have you read it, seen it in your papers? So a farm here applied manure to the field according to their 590. Seems right. A neighbor brought a suit against them because there was bacteria in the groundwater that was found in the well. So a neighbor was hospitalized due to the ingestion of the bacteria in their well water. Obviously, our goal as farmers is to protect, the land and water. And let's face it, a lot of our farms, we live in the house that's right next to it, or near it, or and we don't want our families to get sick or our neighbors. And kind of an interesting story about this. I've gone to a few meetings that talk about neighbors that come, say a farm's trying to get permitted, they want to expand, and the neighbors are there to voice their opinions. And this is kind of a funny story, but when I was at one of the meetings, the neighbor was concerned about health. Fair enough, right? Well, what she was claiming is that the smell from the farm was causing respiratory issues with her husband. Yeah, I mean, maybe that's believable, but I thought it was awfully strange when I was walking out of the meeting, her husband was the one by the door smoking cigarettes. So I'm not sure where his respiratory issues were coming from. Maybe the farm had something to do with it, but I don't know if he was too concerned about it either. So Wilson Mutual versus Falk, where this one had a claim was submitted under their farm liability insurance policy. So their farm owner's policy had liability. They submitted a claim. It was denied by Wilson Mutual based on the pollution exclusion. So you have your liability, you may have an umbrella policy, but there's no coverage for pollution because there's an exclusion in there. Yeah, right, beautiful insurance. So you get that big packet, put all that language in that nobody reads. Somewhere in there, if you would have read it, said pollution is excluded from your liability. So like I said, it was denied. The Supreme Court held that bacteria manure that reaches a well is considered a pollutant, therefore no coverage. So a lot of time, a lot of legal fees to reach the state, so you can imagine what the farm racked up there. The farm, who had a farm owner's policy was essentially uninsured for this loss. So this is unprecedented here. The standard liability insurance sold on farms does not cover losses arising out of contaminant of a pollution event. In all honesty, we knew this. So as an agency, we understood that when we have a policy that has liability, that pollution is separate. I guess a way to relate to it is, if we carry health insurance, we need to buy dental insurance as well if we want that. It's kind of the same here. So you have your liability, but they pull out pollution. And if you want to add pollution, you have to add it as a separate endorsement or buy a separate policy. So what it's saying is the farm liability served no purpose for handling this claim, and therefore not insured. So insurance helps protect you. What about kind of minimizing your risk? Custom operators. You can hire someone as a custom operator to handle, your spraying, your applying of fertilizer, manure, and that would help minimize your risk. That is true, although the farm could be held liable because your manure is involved. You're not free and clear just because you hire someone. More than likely, you'll be named in that suit. You might If the hauler was negligent, you might be able to get out of that, but it's gonna take some attorney's fees to get that far. It does add another layer. I think it is a good thing, but nonetheless, don't feel just because you have a subcontractor handling your fertilizer, your sprays, or your manures that you're automatically free and clear. What some people may do, and what I would recommend, is when you hire people, subcontractors, to do any hauling for you, you could ask them to list you, your farm, on their policy. It's called as a primary non-contributory. So what that means is, if they do something, even though they're handling your product, but it's their negligence, it's no fault of yours, they're just handling your product, their insurance has to not only protect them as a subcontractor, but also you as the named insured. So rather than dragging your insurance into it as well, their insurance not only takes care of the subcontractor, but also you as the business. So many insurance carriers now that are running these custom operators, these manure haulers, their policies do not cover pollution. They have to get a separate policy. But what they're doing is they're requiring that subcontractor, that insured, to take out that policy, likely with a different carrier, provide them proof that, hey, I have this policy for a pollution type of event. Once they provide that proof, that carrier then say, okay, we'll write you. We'll provide you with your general liability. We'll provide you with your auto insurance, your workman's comp, your property, your umbrella. But until you provide us with that proof, we're not going to do it. So we're seeing a little bit of a shift there, that the insurance carriers are putting pressure on manure haulers to do this in order to get all their other insurances that they may need. So add in a layer of protection, like hiring a subcontractor is part of it. Also, obviously, taking on insurance. I'm an agent, so it's probably no surprise to you guys that that's why I'm here to talk. So liability includes bodily injury and property damages arising out of a pollution condition from farming activities. You could also have legal defense costs, which we talked about, civil, criminal fines, penalties. Another thing with farming, a lot of manure chemicals, they're transported by trucks. Likely you need a separate policy than what's included on your farm to cover that sort of issue. So farm is seen in one light. Once you throw it on a licensed vehicle, it's seen in another. So you could also have issues arising out of waste disposal sites, lagoons, manure storage tanks. And then damage to natural resources, so land, water, fish kills, things of that nature may also be brought into it. Excuse me. So options, your standard farm owners policy, you can add an endorsement. Typically, that max is about $1 million. Some carriers might not go that high, depends on who you work with. Typically, like I said, because there's a lot of insurance carriers, it's written on a sudden and accidental occurrence-based form. So what that means is, was the event that happened by accident, and was it sudden? The tanker rolled over and spilled into the ditch. The hose blew and created a manure spill. Things like that. As far as how they're written, a lot of them are written on an occurrence base, and what that means is when the event occurred, were you insured with that insurance carrier? So you're with company A on today's date. There's something that happened, nothing really came of it. You switch insurance carriers next year, and that neighbor's saying, okay, hey, whatever happened on that day, that event there, I want to file a claim. If you change insurance carriers and you have an occurrence-based policy, that's fine. They're on the hook forever, essentially, because they insured you the date of that loss. Now, whether the claim is paid depends on the scenario. The next option I have is a separate policy. So typically it has a higher amount of coverage. It can go up to 10 million. 5 million is more common. Some carriers will go up to 10 million. It's much broader, so it fills in some of the gaps that the sudden and accidental pollutions underneath a farm owner's policy do not cover. It's typically written on a claims-made basis, though. So what claims-made means is while you're insured with that carrier, so 2005, you continue to use them, but you decide to say no in 2017, you go to a different carrier, their period ends. So you're no longer insured with them. They're off the hook for any events that may have occurred in the past that a new claim would be brought up. What happens in that scenario, though, is typically the new carrier, whoever you decide to go with, they'll put a retroactive date on your policy, meaning, and this is important, that they'll assume coverage back to the date you originally took out pollution insurance, even if it was with another carrier. So you'll see a date on your policy from 2005 with a new carrier, even though you weren't insured with them. It helps fill that gap, and it gives you, the luxury of being able to change carriers without saying, well, geez, if I change, all my past history is now eliminated and no longer insured. So just be careful with that. Retroactive dates are important. So with adding an endorsement onto your farm owner's policy, one positive about it, it's really cheap. It's really reasonable. It doesn't cost you a whole lot of money. It's affordable. It does have its limits. The limit of coverage typically isn't as high. Like I mentioned, it's written on a sudden and accidental basis. It doesn't cover those gradual losses that, say you have a tile line next to your lagoon that's been leaking for years, that finally rears its ugly head. That's not a sudden and accidental event. So you wouldn't have coverage for those scenarios. But like I said, it's very cheap. So at a very minimum, I do recommend that. And it has paid a fair amount of losses. So it's not like it's, that once in a million loss that you have that it finally hits and works for. There's plenty of losses that are covered underneath these coverages. Things to note, most pollution claims come from a third party or organization, so you damage someone else's property, claim arises, and you're forced to clean it up and take care of it. Gradual releases, like I mentioned, on lagoon would not be covered typically by an endorsement onto a farm owner's policy. And not all these coverage extensions are the same. All these carriers have different language. Some do define sudden and accidental. Some define sudden as within a 72-hour period. Some do not. So like I said, they're not all the same. This is a very broad, I'm not an attorney,